Mr. Sazed.
Good morning, my lord. My lords, my lady, I propose to address the new argument that was advanced yesterday under the heading or is related in some way to ground 2. Then I'll show you what I still need to in Lipton, bearing in mind, of course, what the court said yesterday. I'll refer very briefly to Skykick, as Mr. Moser did, and then I'll just say something about the concession note that was provided last night, and then hand over to Mr. Otti to deal with ground 3.
How long is all that going to take?
About an hour and a quarter or an hour and a half.
Oh, I see, quite quick. So we should get through this appeal today.
Definitely, my lord.
Oh, good. Made my day.
Made our day.
Well, my lord, since I'm going first, it's very easy for me to say definitely, my lord.
Yes, well, definitely is all I wanted to hear. Great, brilliant. On you go.
So, the new argument yesterday. So ground 2 was, and I quote from paragraph 2 of the appellant's supplementary skeleton argument, Volvo and Eureka are binding on UK courts. Now, in that form, as I understand it, ground 2 has been abandoned. But it's been replaced in oral submissions yesterday by a new ground that even though those decisions of the CJEU are not binding, such decisions find some other way to travel around the ordinary rules of precedent so that Arcadia ceases to bind and the field is clear for the court to apply the cessation requirement, just as if it had been bound.
That's a very sort of long way of saying what he said, but yes, it's a new argument, yes.
Well, my lord, I'm doing my best to understand it from yesterday's transcript.
Even though they're not binding, they are binding.
Well, my lord, that's how I understood it. So
They have the same effect as if they were binding,
yes,
because they would allow us to ignore the doctrine of precedent.
Exactly so, my lord. So that's my understanding of the new argument. And my understanding of the basis of it was that Mr. Moser submitted that it was the principle of supremacy which allowed the court to abrogate domestic laws of precedent and recognise the retrospective declaratory effect of CJEU judgment. And since we still have the principle of supremacy, section 5, those effects continue to apply even post-Brexit. That was how I understood the argument was grounded. Now, as Mr. Moser accepted, this new point was not put to the cat, was not discovered in time for his claimant's skeleton argument, or even their supplementary skeleton argument. Now, if it were right, it would have very far-reaching consequences. It would render CJEU judgments binding in all but name. But it's not right, for reasons I will demonstrate, mainly from materials Mr. Moser showed you, plus one or two he did not. And I'm going to give two separate answers which add up with each other. The first is to demonstrate that even before Brexit, the new argument did not work. And secondly, to show that the position, as you might expect, is even clearer after the Withdrawal Act. So the first answer, pre-Brexit. Now, the new argument started from a concession made in the case of Byrne and MIB in the Authorities Bundle, Volume 3, Tab 36, page 843.
So what started from what?
The new argument,
Yeah.
the argument that I'm addressing, began from a concession made in the case of Byrne and MIB at Volume 3, Tab 36, page 843. And the, I'm sorry, paragraph 843. No, that must be page 843. Page 843. And we looked at a tiny bit of the relevant paragraph. And if we look at it all, we can see halfway between letters G and H that it's a concession. Not that I'm arguing it's wrong, but just to identify. It was accepted by Mr. Crowe on behalf of the Secretary of State that if I accept that the reasoning of that decision of the European Court is applicable here, as I do, under Section 3.1 of the 1972 Act, I must apply and follow that reasoning, even if there's a contrary decision of the Court of Appeal. The obligation to apply the principles of community law, as laid down by the European Court, means the doctrine of precedent is not applicable. See Creed. So the concession that was accepted by my Lord, as Mr. Justice Flo, was referable to Section 3.1 of the European Communities Act and Korean. The relevant Korean is not in the bundle, but it did indeed quote Section 3.1, and having quoted Section 3.1, a judgment of this court said, we do not think that the doctrine of precedent trumps the clear words of the Act. So it's all based on Section 3.1. So the real starting point of my learned friend's argument is Section 3.1 of the 1972 Act. We can look at that. We've got it in tab 1 of the authorities bundle. And if we start on page 9, we see the very familiar Section 2.1, which we now know is the conduit through which European law had effect in the UK. And then at page 2, we have the slightly less familiar Section 2.4, which provides for supremacy. So Section 2.4 says, provision that may be made under subsection 2 includes, subject to Schedule 2, any such provision as might be made by Act of Parliament, and any enactment passed or to be passed, other than one contained in this part of this Act, shall be construed and have effect, subject to the foregoing provisions of this section. And that is the subsection which provides for the supremacy or primacy of EU law over domestic law, because it provides that any enactment, whether passed before or after 1972, is to be construed and have effect, subject to the foregoing provisions of this section, which of course include subsection 2.1. So that's supremacy, primacy. Then on the next page of the bundle, we have section 3.1, which states that for the purpose of all legal proceedings, any questions to the meaning and effect of any of the treaties, or the validity, meaning and effect of any EU instrument shall be treated as a question of law, and if not referred to the European Court, be for determination as such in accordance with the principles laid down by and any relevant decision of the European Court. So that is the statute which this court in Crean and my lord in Byrne accepted overrode the traditional laws of precedent, because it was a statutory requirement to interpret any EU instrument or question of EU law in accordance with the principles laid down and any relevant decision of the European Court. Now, that is not the same as supremacy. And this is the fallacy at the very start of my learned friend's argument yesterday. It's not a manifestation of supremacy. It's something quite different. Supremacy is the supremacy of EU law over domestic law. That is quite a different question to which judicial body is the supreme interpreter of European law. Clearly, if the UK was going to take its place in the European legal order, it was necessary that the European Court be recognised as the supreme interpreter of European law. But it's not the same thing as the supremacy of European law over domestic law. That is simply a different point. They're both part of the European order, which we joined and have now left, but they are not the same thing. Now, my lord, since this appears to be in dispute, because my learned friend said very clearly that it was supremacy that allowed this court to override the rule.
I thought he said section 4.1, not section 5.2.
Well, my lord, he said more than one thing. The argument began with a clear statement that it was supremacy that had the effect that the laws of precedent gave way. Later on, I think the court put to my learned friend, it's all about section 4, and he agreed. I'm afraid I don't understand the section 4 argument. Well, I'll go to section 4 shortly, but I don't understand how it helps my learned friend. I mean, it brings forward his cause of action as the CAP found and as we have always argued. But it doesn't mean he can override precedent. But anyway, my lord, I'll come to that. I will come to the Withdrawal Act. But at the moment, well, I feel I need to address the argument that supremacy had that effect, because it was absolutely clearly stated right near the start of my learned friend's submissions yesterday. It somewhere around page 10 of the transcript. But it was very clear that that's
We've
what
not
he
been
said.
sent the transcript.
I'm so sorry, my lord. I hope those behind me will send it to you. It didn't come till quite late last night in any event. But it was very clear when the argument began, it was focused on Section 5 and supremacy. So I do feel I need to address it. We do have in the bundle 3 statements of what supremacy is, which confirm the point I've just made, that supremacy is about the supremacy of European law over domestic law. Now, I don't know if your lordships want to see them, but I'll certainly give references to them, and I'm very happy to turn them up if it would assist, but it may be the point's obvious.
But the point in Byrne was the different point about the fact that decisions of the European Court as to what European law would take precedence over any contrary decision of the Court of Appeal, which was the case of Miguel and Reading, and that's why the doctrine of precedent didn't apply.
Yes, exactly so, my lord, and that's the
Well, it did
submission
apply, but it applied to the decision of the European Court.
Yes, it had been applied with the
As
modification.
it would have done if it had been the Supreme Court. If there'd been a contrary decision of the Supreme Court, or at this stage the House of Lords, then I would have been bound to follow that as a superior court. But it's really about which is the superior court, this passage in Byrne.
Exactly so, my lord.
And you say, since Brexit, none of that applies.
I will be saying that. At the moment, I'm still on my first point.
No, I understand.
Which is that even pre-Brexit,
trying to
supremacy did not have this effect. But my lord understands my submission correctly, that the Section 3 point about which court binds is not the same as the supremacy point. So can I just give, I'll just give references to where there are definitions of supremacy in the bundle, all of which make clear that it's about supremacy of European law over domestic law. There's Miller 1, paragraph 66, in Authorities, page 1020. It's tab 42. Paragraph 66 of Miller 1 expressly makes the point that I have submitted, that Section 2.4 is the one that brings in supremacy. There's also the explanatory note to the Withdrawal Act, which we have at Authorities, tab 88, page 2586, paragraph 62. Explains supremacy in the same sense.
Which page is the explanatory note?
It's page 2586.
Yeah.
And thirdly, in Lord Reed's judgment in Skykick, in Authorities, tab 70, page 2222, paragraph 480. And all 3 of those explain supremacy in the same sense as I have submitted. So, Section 3.1 was understood pre-Brexit to make it either explicit or implicit in Section 3.1 that the European Court effectively took the place of the higher court, as my Lord the Chancellor has put to me, in our system of precedent, and that we couldn't be hidebound by saying, well, the Court of Appeal is above the European Court of Justice in that sense. So to that extent, the rule of precedent was modified. Now, my lords, my lady, does that mean that the day after this court gave its judgment in Arcadia, another division, or for that matter the same division of this court, would have been free to say, well, the court misinterpreted European law in Arcadia, just got it wrong. Supremacy means that we have to get the European law right, and therefore we reach an opposite decision. Well, if it could have said that, then of course the next day after that, another court could have said the opposite, and chaos would have ensued. If the court could say it, then people could argue it. But no one has ever suggested that was the position pre-Brexit. And the important question really is, why not? And the answer is, because the modification to the rules of precedent required by Section 3.1 was limited to that which was required to comply with Section 3.1. There was no greater modification to the rules of precedent than that. It was never the law, even before Brexit, that if a matter was one of European law, then the Court of Appeal was free to depart from its previous authorities. The only modification was that where there was a clear decision of the European Court, with which a Court of Appeal decision could not stand, then the Court of Appeal decision would have to give way. And the proposition that the modification to the laws of precedent went no further than that is made good by an authority in the bundle at Authorities tab 35, called Oburn and Aventis. Oddly enough, it's the tab just before Burn.
Yeah.
Oburn. It's a decision of this court. I should make it clear that on the main point it decided it was overturned by the House of Lords, but there was no reference to the points I'm going to show you. And you see, if you just go to page 804, you can see that there was a single judgment of the court. And if we then go down to page 814, paragraphs 33 to 35 explain that. It doesn't really matter what the underlying material was, but the court in Horne-Roberts was considering the very point that arises in this appeal, decided it in clear terms. We are, of course, bound by that decision, and in principle we must follow it. However, Mr. Leggett submits that we are not bound to follow Horne-Roberts' case because of a decision of the Court of Justice in this very case. And he relies on the second exception to the general rule in Young versus Bristol Aeroplane. He submits that this exception must now be extended to include rulings of the Court of Justice, and he puts his submission thus and explains it without reference to either Section 3 or CREA. And he goes on to essentially to put it in terms that the European Court stands in the shoes of the House of Lords for the purpose of being the supreme authority for the interpretation of European law. And then at paragraph 35, the court says, assuming such a principle to exist, it could, in our judgment, only apply if the previous decision of this court, or presumably the House of Lords, were clearly inconsistent with the decision of the Court of Justice. We will therefore consider the judgment and reasoning of the Court of Justice in this case before returning briefly to the exception to the doctrine of stare decisis suggested by Mr. Leggett. And they do return to it at page 818, paragraphs 50 to 51, where the court says, having considered the relevant decision of the European Court, in all these circumstances, we do not accept Mr. Leggett's submission on the first issue, but we conclude that Section 35 of the 1980 Act is capable of applying where the 10-year period is expired. In short, we do not read the decision or reasoning of the Court of Justice as being inconsistent with the decision or reasoning of this court in Horne-Roberts. It follows that the question whether there's an exception to the principle of stare decisis of the kind suggested by Mr. Leggett does not arise. It's an important question which should only be determined when it arises for decision on the facts of a particular case. In the instant case, we have simply sought to apply the reasoning of the Court of Justice to the relevant facts, which is, of course, the role of the National Court after a reference. In all the circumstances, we hold that we remain bound by Horne-Roberts' case, and we should follow it. We should add that it was, in our opinion, correctly decided, is consistent with the decision and reasoning of the Court of Justice. So what that extract shows is that even before Brexit, the general rules of precedent were still respected and applied by this court, subject only to the recognition of the superior authority of the European Court of Justice as an interpreter of points of European law. So even before Brexit, Arcadia would have bound this court. And the only
even on that question, as to whether the decision of the European Court would override a previous decision of the Court of Appeal, so they weren't bound by it, was actually left open. That's the question they leave open, isn't it?
It was, my lord. I mean, I don't want to make too much of that in circumstances where it's not clear whether they were looking at either Section 3 or CREA.
No, sure, I understand.
But you're right, my lord. The court was concerned as to exactly the width of it, and essentially the width of it was never tested before Brexit. But what was clear was that it was never going to go further than was required to comply with Section 3.
Yeah.
So the effect of that is that up until IPCD, this court was bound by Arcadia, and the only way in which it would cease to be bound by Arcadia is if some new decision came along of the Supreme Court or of the European Court of Justice, which was clearly inconsistent with Arcadia. And what is rather critical is that Mr. Moser concedes in this appeal that there is no relevant binding Court of Justice decision, and he does not contend that there's any relevant decision before IPCD. So, given that concession and that omission in his argument, his alternative argument would not have worked to undermine Arcadia even before IPCD.
So what if Manfredi was in fact, contrary to what obviously you say, a binding decision as to this principle of EU law, which the Court of Appeal misinterpreted?
Well, my lord, the submission I've just made is that that submission is not one that could have been accepted because of the law of binding precedent.
Right. So
this court could not have entertained...
It doesn't matter. I mean, if Manfredi had been after Arcadia, it would matter.
Yes.
But because it was before and looked at in Arcadia, we have to go with our system of precedent.
Exactly. And of course, per incuriam is out there. I mean, if someone could suggest, which of course they could not, that Manfredi was not before the Court of Appeal in Arcadia, then someone could argue it was per incuriam in accordance with our usual rules. But what could not be done is to argue that it was just misinterpreted.
Yeah.
I'm sorry.
So it would only be if... So this court would be bound by the interpretation of another division of this court previously as to the meaning of a particular EU decision or as to what EU law was, unless there's a subsequent decision before completion day of the European Court saying that or putting forward a different, inconsistent analysis.
Yes, exactly.
Yeah, okay.
And then I move to my second argument, which is that, not really very surprisingly, the position for the appellants on this point is worse, not better, with the Withdrawal Act. And I'd like to go back to the Withdrawal Act, which is in the Authorities Bundle at tab 12, page 176. And we start at page 176 with section 1. The European Communities Act 1932 is repealed on exit. And of course, that includes repealing section 3. So section 3 is not the law after exit. So my learned friend, to get his argument going, would need to find a new basis for the argument that the law of precedent is different in relation to European matters, because section 3 has gone. And at page 185 we have section 4, which sweeps up the remaining EU rights and so on that have not been brought forward into domestic law by sections 2 and 3. And we know from Lipton that that includes the claimant's causes of action in this case, just as the CAT found. They become part of retained EU law by virtue of section 4. So section 4 brings the cause of action within retained EU law. It's what the CAT found, it's the point that what Lipton said was correct, and it's a point which, while it was apparently being argued previously, was not pursued orally by Mr. Moser anything different. Now, if there's an argument that section 4 itself in some way modifies rules of precedent, I'm afraid I did not understand that argument yesterday. So I hope the court will ask me about it if there is some argument based on the wording of section 4. Where I was going next was to point out that section 4.3 provides that this section is subject to section 5 and schedule 1. So we then go, if we may, to section 5 on page 187, and there's Section 5.2, upon which Mr. Moser relied.
I mean, just before you
Yes.
you go away from section 4.1, which you don't understand, my note of well, I mean, it's because I taxed him, if I remember rightly, with which of rights, powers, liabilities, obligations, restrictions, remedies, and procedures had the effect he was contending for. And I thought I remembered that he said powers, obligations, remedies, something like that.
I think the word procedures got some emphasis at that point in the argument.
Maybe procedures. Now, I just want to just give me a second before you go away from this, because I don't want you to just ignore it on the basis that you don't understand it. If you do, what he was saying was, I think, so he said, Eureka is clear. It's unnecessary to go to the Supreme Court because the Act tells us you have all the powers you had before Brexit, including not following Arcadia, on the ground that EU law is now made clear post-Brexit. Right. So I assume that comes from any powers which immediately before IP completion day are recognised and available in domestic law by virtue of section 2.1, are enforced, allowed and followed accordingly.
Yes, I'm terribly grateful, my lord. So the one answer to that I've already given is that if you could call it a power to override the previous rule of precedent by inserting the European Court at the top, then that was a power which was not recognised or available by virtue of section 2.1. It was you call it a power, it was a power that became required to be exercised in order to comply with section 3. And that is a rather less narrow point than it seems, because of course the whole point of section 4 is to bring forward substantive rights, powers, obligations, restrictions, remedies and procedures in European law and make them part of domestic law as retained EU.
But isn't the answer to that point the fallacy you've already identified? That it'd be one thing if there were a decision of the European Court post-Arcadia, pre-Brexit, that would therefore be binding. That would be a right, power, whichever it is, recognised and available in domestic law by virtue of section 2 at that stage, would continue. I mean, you accept, as you have to, that if there'd been a decision, if Eureka had taken place in 2016, 2017, after Arcadia, well, that would be a different matter. But the point is that it doesn't. So there isn't anything that's covered by section 4, because Eureka is post-Brexit.
Yes, I mean, there'll be a debate about what exactly Eureka really does decide. But
No, that's a different issue. But
it would be
post-Brexit,
yes.
Decisions of the European Court aren't binding.
Yeah.
With their own, we can have regard to them, but section 6.1 provides in terms that they're not binding.
Yes. Well, that's absolutely right.
So it's a bootstraps argument, really.
Yes, exactly. And I think, it is important to look at. We're going to look at the other section.
But you see, I mean, I hear what my lord says, but I think it simply proves too much as an argument, because it runs into section 6.1, and even if it were right that on one analysis of section 4 you could say that these words, rights, powers, liabilities, obligations, restrictions, remedies and procedures, included sort of unwritten EU law principles that had not been understood properly by our court, which is what he's saying. it runs directly into Section 6.1, which says that they're no longer, says expressly
Not bound by it.
what the regime is afterwards, namely that a court is not bound by those principles after completion day. So, that was what I found as the problem. Even if you could use those words, and I tried to get Mr. Moser, if you remember, to tell me which of those words had that consequence. But so I think that both my Lord's point and that point rather put the kibosh on it. But I sort of understood it when he was saying it, because of his eloquence, I'm sure.
Yeah. Well, I entirely
Well,
agree.
he said as a principle of European law. My understanding was he was saying it was a principle of European law, which is effectively being clarified by Volvo and Eureka, but it was a pre-existing principle, and therefore we should apply it. And you say no, it isn't, because the cases before Volvo and Eureka do not include this requirement of a cessation.
Well, that's absolutely right, my lord, and that's ground 3, which Mr. Otti is going to discuss
sure.
in more
I mean,
detail.
that's-
I
Comes back to
think
the
he
same
was.
point, isn't it?
I think he was going further than that. I think he was saying that Eureka simply clarified what had we, even though we didn't realise it, was always the principle of European law, namely the cessation requirement. And so we should have known that, and we didn't. And Arcadia didn't recognise it, even though Manfredi told them it was. And the European law is European law, even if it's only clarified after Brexit Day. So it was European law prior to and during Arcadia, and that's roughly what Eureka said, he says. And therefore, this section 4, taken together with the supremacy section, but the supremacy section, for the reasons you've said, is addressing a different point. But this section is enough to get him home. As I say, to me, that doesn't work really for a number of reasons. But what I'm trying to do is to encapsulate the argument. It's unhelpful not to have the argument written down. When skeletons are quite useful because they actually enable you to see written down the argument. In fact, I might even encourage Mr. Moser to do it. I know he's already produced 2 documents overnight, for which I'm grateful. But I think it would be helpful, because without a skeleton, we're not, we're clutching at straws to try and understand it.
Yes, although if it turns out to be a different argument to the one that any of us have so far understood, then that might put in danger my definiteness this morning as to when we were going to finish this appeal. But let's assume we've understood it more or less.
Okay.
My lords, my lady, I entirely endorse the point that you couldn't put any such construction on Section 4 because of what we're going to find in Section 6. I'm going to come to that in just a moment.
But you're making a slightly different point as well, which is that Section 4 is effectively derived from and reflects Section 2 of the 1972 Act.
Yes, exactly.
And not Section 3.
Exactly. So at the moment, I'm also making the narrower point that even looked at literally, Section 4 is clearly not intended to have the effect that's contended for. It's intended to bring in the substantive European law, which was what was brought in by Section 2. So, my lord, that's Section 4, and as I say, it's important to see that it's subject to Section 5 and Schedule 1. We then go to Section 5 on page 187, and we see
none of the, as it were, saving provisions. That's section 3, 4, 5, or 2, 3, and 4.
Yes.
The Withdrawal Act preserve Section 3, do they?
No, certainly not.
No.
I mean, that would obviously
not even as it were pro tem.
No, I mean that would be plumbing consistent with Section 6.
Well, quite.
I mean, to the extent you get to it, it's in Section 6.
Yeah.
And then all I wanted to draw attention to in Section 5, apart from the points I've already made about supremacy under 5.2, is that Section 5.6 gives effect to Schedule 1, which we've just seen Schedule 4 is subject to. So the next thing we want to look at before Section 6 is Schedule 1, which is given effect by Section 5. We've got Schedule 1 at page 218. and at paragraph 2 at the foot of 218 provides that no general principle of EU law is part of domestic law after IPCD if it was not recognised as a general principle in a case decided before IPCD. And then on the next page, 219...
So where were you reading?
I was reading from the foot of page 218, my lord.
Schedule 1.
Schedule 1, paragraph 2.
Paragraph 2.
And
You say that that's directly relevant?
Not directly, my lady. I'm saying that it indicates that it is consistent with the other provisions that we're about to go to that show that the principles of EU law are as they were at IPCD.
So if the principle on which Mr. Moser now relies, because he says, oh well, Eureka and Volvo Eureka clarify what European law is and always has been, ex tunc and nunc and all the rest of it, since time began. You would say this is an answer to that point, because unless a previous decision of the European courts has recognised that width of principle, it's nothing to the point that some subsequent decision says that the principle is actually wider.
My lord, yes, if it was only that paragraph, then there would obviously be some scope for debate as to whether that included modifications of the principle that might later be declared to have always existed, which, as I understand it, is the way Mr. Moser, one of the ways in which he sought to put it. And that's why I answer my lady by saying it's not the best paragraph I've got, but it is consistent. So I just draw your attention to it.
Yeah, okay.
But more significantly still in Schedule 1 is paragraph 5 on page 219, which is headed Interpretation. And paragraph 5 on page 219, 5.1, provides that references in section 5 and this schedule to the principle of supremacy of EU law, any general principle of EU law, and other matters, are to be read as references to that principle so far as it would otherwise continue to be or form part of domestic law on or after IPCD by virtue of section 234 or 63 or 66 and otherwise in accordance with this act. So just stopping there, if supremacy ever had any relationship with the role of the European Court, which I've submitted it never did, then the Withdrawal Act makes it explicitly clear that after IPCD, supremacy has effect only within the system of retained EU law. Then we have subparagraph 2 of paragraph 5 of Schedule 1. Accordingly, among other things, the references to the principle of supremacy of EU law in section 5, 2 and 3 do not include anything which would bring into domestic law any modification of EU law which is adopted or notified, comes into force or only applies after IPCD. Now,
that's the slam dunk one for you.
It's one of them. There's still more. There's still more, my lord. I mean, it's absolutely clear that the Withdrawal Act does not support my learned friend's argument, but this is one.
Just is that slam dunk? On the face of it, it might apply to changes actually introduced rather than the sort of declaratory effect.
It would be a possible reading, my lady. I
Yes, so
accept
you're not going to rely only on that, are you?
Not only on this, no. But I'm showing you that there are a number of very consistent provisions in this Act.
Yeah.
Which
When you add them all up.
Sorry.
Your point is that when you add them all up.
Well, yes, you can see what the intention is, and the one thing that it is not is to somehow bring back Section 3 by some side door. Mm-hmm. Now, I mean, if my first point is right, then supremacy never had anything to do with the debate. But if Mr. Moser were right that supremacy might have assisted him on ground 2, then this provision would ensure that it is not designed to reopen the conduit pipe that was closed by the 1972, by the repeal of the 1972 Act. I mean, that is what this provision is saying, is that the references do not include anything that would bring into domestic law any modification of EU law that is adopted or notified comes into force or only applies. Now, again, I accept there is scope for argument about whether
It's
that
not a modification.
whether it's a modification, but it is absolutely clear that the intention of Parliament is that as EU law changes and develops after IPCD, that is not brought into domestic law, and in this occasion it's not brought in by the principle of supremacy. Now, my lords, my lady, we then go back to section 6, which is the key one, but it has to be, but it's understood in the context of these other provisions as well. So that's page 190, the same tab. Section 6.1, of course, is very clear. The court is not bound by any principles laid down, decisions made after IPCD by the European Court, and B, cannot refer any matter to the European Court. Now, it is no accident that the inability to refer is put in the same subsection as effectively the opposite side of the coin of not being bound. The ability to refer is absolutely essential for the working of the system in which the European Court has supreme authority as the interpreter of European law. But many of the things it's interpreting are in the context of individual national laws. And in those circumstances, if the system is to function at all, it is absolutely essential that a national court can refer. So it's no accident that those two are together. Section 6.2 is the have regard section. Now, yesterday, the court was encouraged to start reading that after the comma. A court or tribunal may have regard to anything done. And if you do start reading it after the comma, then of course you're left with, well, what do they mean by have regard? That could be anything. Could be, well, you can see it's there. It could be you're more or less bound. But if we start reading at the beginning of the sentence, it makes a bit more sense. So subsection 2 is subject to this, which must be subsection 1, i.e. it is subject to not being bound. So that's the one provision that's absolutely clear, is that this court is not bound by anything said by the European Court. It's also subject to subsections 3 to 6. And subsection 3 is important here. Any question as to the validity, meaning or effect of any retained EU law, and I'll show you the definitions in a moment, is to be decided so far as that law is unmodified on or after IPCD, and so far as they're relevant to it, in accordance with any retained case law and any retained general principles of EU law, having regard to the limits of EU competencies. And I'm, as you've heard, I'm stressing the words retained. So we then need to look at the definitions. What is retained EU law? What are retained case law and so on? And they are at subsection 7 on page 192. And your lordships, my ladies, see that halfway down, retained EU case law means principles laid down by decisions of the European Court. And then this is an important phrase. As they have effect in EU law immediately before IPCD. The same a few lines down for retained EU law, anything which continues to be domestic law by virtues of section 2, 3 or 4 or subsections 3 and 6 above. So the law that's brought forward into domestic law is called retained EU law. And then retained general principles of EU law means the general principles of EU law, and again that phrase, as they have effect in EU law immediately before IPCD. So the duty of any court in the UK is to interpret retained EU law by reference to case law and principles as they had effect immediately before IPCD. And that is my submission as to what the real slam dunk is. When one has looked at the context and what this Act is trying to achieve, with some help from Lipton as to what it's trying to achieve, those words are absolutely plain. That the question for the court is how did those rules, those principles, have effect before IPCD? And anything that happens after IPCD to change their effect is, to all intents and purposes,
why is that any more slam dunk? Because doesn't that also admit of the, or potentially admit of the argument that actually the EU law did have the effect of importing this requirement. See Manfredi and see the post-IPCD declaration of what EU law was before.
Well, the answer to that, my lord, is no. And there are two different answers for the two different parts of my lord's question. As to Manfredi, the simple answer is that's not open in this court because that's been dealt with in Arcadia. And the rules of precedent still apply. As to post-IPC decisions, the simple answer is that these definitions and Section 6 clearly mean that the retrospective declaratory effect of the European Court does not apply in domestic law anymore. So the fact that within the European legal order, the theory, just like it is in the common law world, the theory is that any statement as to a general principle dates back forever. While that is the theory within the European legal order, we have left the European legal order, and these provisions make it quite clear that that retrospective effect does not apply in this court. This court has to consider and decide what effect the principle had immediately before IPCD. And that does not admit of saying, well, some other court somewhere in the world, even one with great expertise in European law, has said, oh, it always had that effect. This court has to consider what effect it actually had.
I mean, that picks up a point that troubled me during the course of Mr. Moses' submissions yesterday, which is so much of what comes from the European Court is as it were, a developing process. And if it were the case that Volvo and Eureka somehow had the effect for which Mr. Moser contended, it drives a coach and horses through Section 6.1. And in fact, Section 6.1 would only have any effect if the decision of the European Court in question was in relation to some entirely new principle that hadn't previously been articulated in any form whatsoever by the European Court in the past, which is probably extremely unlikely after all these years.
Yeah, maybe. My lord, yes, I entirely adopt that. And the point I'm making is that when one looks at all of the definitions together, and in particular in my submission, the definitions of retained EU law and retained general principles, it's actually crystal clear that there is a fork in the road in terms of the development of retained EU law. EU law is domesticated so far as it's not thereafter changed by Parliament, and it continues to develop in accordance with the principles and the effect it had immediately before
Well,
IPCD.
I mean, you're right to direct us to Schedule 1 to Section 6.5, but Section 6.1 is itself pretty clear.
Section 6.1 is pretty clear, but what is less clear?
I mean, I agree that understanding how the rest of the legislation elucidates Section 6.1 is very helpful, but to me, it's really fairly clear that Section 6.1 does not allow Section 4 or Section 5 to be interpreted in the way he tries to interpret.
Well, my lord, of course I'm quite content with that, but I have to answer Mr. Moses' submissions, which were that while he accepts this court is not bound, nevertheless, it becomes rather important. And so it may be that my submissions are not really seeking to elucidate Section 6.1, which is crystal clear. They're really seeking to elucidate Section 6.2, which, as my learned friend advanced the matter, was rather less clear. Because if you don't look at what Section 6.2 is subject to, you have no guidance. But if you do look at what it's subject to, then you have ample guidance as to what the task of the court actually is. And it cannot possibly include any weight being given to the retrospective declaratory theory in the European legal order, which is not the legal order within which these questions are now being decided by this court. So, my lord, that is why after Brexit, the position gets worse for my learned friend and not better.
You're really saying that a frozen version of EU law, both as to statutory regulations, whatever they are, and the development of the case law, is frozen at IPCD.
Yes, I mean it's not quite frozen in the sense that it can be developed in accordance with this court's
But it's up to the
principles
courts
and
of this
Parliament.
jurisdiction
Yes.
to decide how to
Exactly.
do so.
Exactly so. Exactly
So
so.
coming back to the exercise of the discretion within 6.2,
Yes.
where does that usually have regard to?
I pick up a point that was raised in argument.
Because there's still
yesterday.
scope to.
Yes,
do so.
it is in fact very, very similar to the position with judgment from somewhere else in the common law world. If the reasoning in it is persuasive as to what the effect of the principle was before IPCD, then the court can follow it. Obviously, we would say this court cannot follow it on this point because we're bound by Arcadia.
Yeah.
But in general principle, if the reasoning is persuasive, the court can say, well, that's persuasive reasoning. I agree with it. If it's not persuasive, then the fact that the European Court has said it is no longer of any weight. It's all about the reasoning. And in that respect, it is no different to a Commonwealth authority in a common law case.
Yeah.
And there's no reason why it should be. I mean, an Australian judge is no doubt bound by the High Court of Australia. Within the Australian legal order, the High Court of Australia is the ultimate interpreter of the common law. We look at it differently in this court and in our courts and in our legal order. They are a highly respected court which may have some very useful reasons and thoughts which may or may not in the end contribute to our law. And that's the exact position now of the European Court in relation to most matters, certainly in relation to all of the retained EU law, which includes the claimant's claims in this case. So that is the answer. It's simply that process. You can look at the reasons. If persuaded by them, you can adopt them. But there's no reason to give them any more weight than that. Now, my Lord, I've made this argument by reference to the statute. It is supported by the explanatory note as well. I can just show you that briefly, if I may. Authorities, first paragraph is in Authorities, Volume 8, tab 88, page 2597, paragraph 110. The last sentence is consistent with my case.
The last sentence of what?
Of paragraph 110.
Yeah.
Page 2597. So far as, for example, the court may have regard to post-exit decisions, it cannot have regard to such an extent it considers itself bound by them, and that is actually a sort of rather direct riposte to the argument yesterday. And we've also added last night a further extract from the explanatory note, which wasn't in the bundle. So I don't know whether you, my lords and my lady, have this electronically or in hard copy. It's the further extract from the explanatory note, which should include at internal page 47, paragraph 278. Can I just check whether you have that in any form?
No.
I've got it.
It was
I don't.
I don't. Well, I did. I looked at it, but I didn't. We had a problem.
Can I hand up a copy? And I hope I'm forgiven for putting in things at the last minute, but as I say, we did not actually know this argument was being made.
No,
We
sure.
learned it yesterday.
Well, you can just read it out, 278.
Well, I'm very grateful. Unfortunately, I've now given away my last copy.
I read it out. It says, generally, the meaning or effect of the law in other jurisdictions is treated as a question of fact to be proved in legal proceedings by evidence, rather than determined by a judge as a question of law. Section 3 of the European Communities Act 1972 clarified that when the UK joined the EU, when the UK joined the EU, UK judges were to determine the meaning or effect of the EU treaties or the validity, meaning or effect of any EU instrument as a question of law in accordance with principles laid down by the relevant decisions of the CJEU. The EU law which is being retained by the Act will become domestic law and so fall to be interpreted by judges in this country.
My Lord, yes, and I say that that supports the argument I
Yeah.
have made.
Yep.
Now, so my Lord, that's my two arguments, which do seem to have taken me slightly longer than I originally predicted. And so the second thing I wanted to do was to just show you some of, very shortly indeed, as shortly as I can, some of the aspects of Lipton as to how they bear on this, because there are, of course, statements in Lipton which also bear on the intention of the legislation. So I'm going to try and go through at a cracking pace on the basis that my lord and my lady will clearly familiarise themselves with Lipton at the start. So it's in the Authorities Bundle, Volume 6, tab 66, page 1879, and as you know, there is a one clear majority judgment which was delivered by Lord Sales and Lady Rose, with whom Lady Simler agreed, beginning at the foot of 1883 in our bundle. The facts and two grounds of appeal are set out at paragraphs 1 to 4. And I just ask you to note a point I'm going to come back to, which is at the end of paragraph 1, that the claim was for compensation for €250, which is translated as about £220. I'll come back to that. Now, the grounds set out there, the two issues, and if you put them in logical order, before you knew the outcome of either of them, ground 2 would come before ground 1. So you decide what the applicable law is, then you apply it. And of course, that is precisely what the majority did. Section 2 sets out the undisputed facts. Section 3 turns to the implementation of Brexit. The history of the legislation is set out at paragraphs 10 to 21. At paragraph 16 on page 1886, there is a quotation from the explanatory note to the Withdrawal Agreement Act 2020, and I draw attention to paragraph 23 within the quote, which refers to the conversion of EU law into retained EU law, and the domestication of historic Court of Justice case law that can take place at the end of implementation period. And again, that's very consistent with the submissions I've just been making, that it is historic case law which is domesticated. My Lord, page 188, at paragraph 22, the majority say another key aim of Brexit was to reduce the influence of the case law of the Court of Justice on domestic law. This was achieved by Section 6, which is discussed in detail below, and there's then a summary of what's provided by Section 6, and that includes subparagraph C, that any question of the effect of retained EU law is generally to be decided in accordance with relevant retained case law, Section 6.3. So that paraphrases the effect of Section 6.3 to which Section 6.2 is subject, in a way saying that that is, and their interpretation of that is that that's generally the approach. So 6.2 is an exception to that general approach, and that's the point I take from that. And just so you know, I'm sure you probably do, that section paragraph 23, they refer to the change in terminology. Technically, it's all now assimilated EU law rather than retained EU law, but for the purposes of this case, we're still under the sort of pre-REULA regime, so we're calling it retained EU law. 23D is relevant to the question what's arbiter and ratio in this judgment. The majority say that the repeal of certain sections of the Withdrawal Act are sections that are central to the application of the law to the Lipton's claim, including Section 4. So their view is that this is important to their decision. And then 24 just records the REUL Act, which is not material to Lipton or our case. And the reason for that is Section 22, which I just mention so that your lordships have a complete picture. Section 22 is in the authorities bundle at page 328.
So what is, just explain to me in words of one syllable why the new legislation doesn't apply?
It doesn't apply because section 22, which is at
Section 22 of what?
Of REUL Act, provides that the changes that the REUL Act makes do not apply to anything occurring before the end of 2023. And that's in our authorities bundle at page 328. So that's not part of my argument. To some extent, I'm just mentioning things that I hope will be of use to the court. We don't need to worry about the trading cooperation agreement, but at the foot of 1889, the air passenger compensation regime is mentioned. We don't need to worry about the details. Paragraph 33 and 34, though, I'll just return to this point about the amount. So paragraphs 33 and 34 recite that the original EU regulation was converted after Brexit into some domestic regulations. And at paragraph 34, you see that among the changes made was that the compensation became £220 instead of €250. And again, I'm going to come back to it. Section 5 of the judgment then sets out the proceedings below. And just to summarise them, both the Deputy District Judge and the Circuit Judge held that extraordinary circumstances defence succeeded, and they did not discuss which version of the regulation applied. Paragraph 40 records that the grounds of appeal to the Court of Appeal included the question of extraordinary circumstances and an agreed note about post-Brexit, which is interesting because it doesn't appear in the Court of Appeal judgment. 41 to 46 summarises the Court of Appeal judgment, and at 47 the majority say in terms that ground 2 raises a prior question. It makes sense to address ground 2 first, as that ground raises the prior question of what law applies, and this is relevant again to whether there is any serious argument that this is not ratio. Then we have section 6 of the judgment, which addresses ground 2. Paragraph 49 identifies that the Lipton's cause of action had fully accrued before Brexit under directly effective EU law. Paragraph 50, it was common ground that the cause of action was not abrogated. The question is what prevented it being extinguished. The provisions of the Brexit legislation are then set out over several pages, down to the end of paragraph 57 on page 1897 of the bundle, and those are the same provisions that are relevant in our case. Paragraph 58 sets out the interpretation under section 16, and then the rival analysis. So again, in terms of what's ratio, the two analyses were argued explicitly before the Supreme Court, and paragraph 60 addresses the question, why does the choice of analysis matter? And the majority holds explicitly that the choice of analysis does matter to the case they're deciding. And one of the reasons is, I can't see the reference to it, paragraph 62 gives the specific reason why it matters to determine which version of the regulation applies to a given set of facts. The amended, and so as we've seen, there's actually a slightly different sum of money. The compensation may be of similar value, but it's not identical. And section 63 says that the Court of Appeal held the amended version applied. Paragraph 66, the Court of Appeal was in error in that. It was actually the former EU version which was brought forward. So that does mean that while they say the appeal was dismissed, in fact there must have been some amendment to the order resulting from the Court of Appeal, because the amount of compensation should have been in euros and not in pounds, and is a different sum of money. So in fact another reason why all of this has to be ratio. At paragraph 69 to 80, the majority disagree with the Court of Appeal about the Trade and Cooperation Act, and what I want to show you on that really is that at paragraph 80, they give explicit guidance to lower courts to ignore what the Court of Appeal has said on that issue. That's an example of where the Supreme Court just decides to give guidance. It must be binding, otherwise there would be chaos. They then go into the analysis of the Brexit legislation itself. And I think you've already noted paragraph 82, where the majority say it's important that courts and tribunals at all levels of the judiciary know the status of CJEU case law. Paragraph 83.
Sorry, where is that?
82.
Paragraph 82 on page 1903 of the bundle, and the last line of that paragraph is the one that I have just more or less quoted.
But it says what follows is therefore strictly overturned.
It does. It does, my lord. And the question and the submissions that I would have made at greater length today, had I not been very strongly discouraged, were partly to the effect that the phrase "strictly overturned" does not mean non-binding. And your lordship asked yesterday, why have we got young Sam in the bundle? Well, one of the things that's quite expressly stated in young Sam is that the phrase "strictly obiter" or "technically obiter" does not mean the same thing as non-binding or a mere obiter dictum. It's often used in exactly how it's used here, to mean it doesn't affect whether we allow or dismiss the appeal. But nevertheless, we give guidance to lower courts. And when the Supreme Court does that, it is not for a lower court to say it's not binding.
I mean, that's, as I said to you yesterday, all very interesting. But the approach this court is going to adopt, because we haven't had Mr. Moser arguing that it is non-binding and therefore we should not follow it, is to say we find a very recent judgment of the Supreme Court, whether it's obiter strictly, non-strictly, or ratio, is something we should follow in this instance.
Well,
if anybody wants to question it, they should go and ask the Supreme Court.
My lord, I've tailored my submissions to that indication
Exactly.
that you gave yesterday, and the submission I've just made was in response to your lordship
Yes.
putting to me.
No, but I
They
mean,
say
but
strictly
you're,
overturned.
you're showing us that this is all ratio, which it may well be, but we're not going to decide that question because it doesn't need to be decided. That's the point.
Well, I'm showing you that there's actually no serious issue about that, which goes to the question of what this concession is doing in this case, which we'll come to. I'm going to come to later. What is this very odd concession, which I'm coming to shortly? There's no real argument that this isn't ratio. It's obviously ratio, my submission.
Okay.
There we are. 83 brings forward, summarises that the complete code is the right analysis, and in that case it was section 3. Paragraph 87 holds that so on page 1904, halfway down paragraph 87, the first is that it respects what we see as the fundamental purpose of the Withdrawal Act, which is to provide comprehensively for the post-Brexit legal landscape. So that they see as the fundamental purpose of the Withdrawal Act, and that then makes clear how a court should apply case law, because an accrued cause of action is retained EU law within the meaning of section 6. And that's also quite hard in my submission to square with Mr. Moser's alternative argument. Then paragraph 88 to 90 reject the Interpretation Act for reasons that they give. Paragraph 91 is relevant because it holds in terms that section 4 sweeps up all the rights that are not covered by sections 2 and 3, which covers the present case, and again confirms that the Act is intended to make a comprehensive provision. They then deal with and reject objections all the way through to paragraph 106 on page 1910, and they then deal with the problems of the Interpretation Act analysis, and the most significant of those, paragraph 107, is the difficulty of applying section 6. So section 6 is very important, but maybe that's not in dispute anymore. And then look at 107B, if I may, which is that, again, sections 6, 3 to 5 are summarised in a way which is consistent with my argument, but hard to square with my learned friends. Just point out, in case your lordships are saying anything about this judgment, that there's a typo in the first line of page 1911. It should be the subheading to section 6 is wrong. The majority point out at the end of paragraph 110 that the accrual of accrued causes of action is not a negligible matter that could have been missed by the draftsman. And that's quite important to the debates in this case. The draftsman has intended to cover this situation, so that is important. And at 115, on page 1913, halfway through the paragraph, a fundamental object of Brexit was to remove the supremacy of the CJEU. 116, they address the decision of the CAT in our case. They consider commentary on the CAT decision. They reject the criticisms of it. At 126, they uphold the analysis of the majority of the CAT in our case, as opposed to that of Mr. Justice Roth. And then the conclusion is summarised at 128 and reasons at 129 to 131. And paragraph 132 is another paragraph that makes it clear that the analysis of Brexit issues is part of the chosen ratio of the majority. Ground 1 is obviously less important to us. Paragraph 158 is the reference to TAP Portugal, which was persuasive because it was well in line with the principles and the general pattern of cases that emerged pre-Brexit. It was persuasive having regard to the degree of fit with previous jurisprudence. So that is entirely in line with my submission about when regard should be paid to a post-IPCD authority. It is to be assessed with its degree of fit with the pre-IPCD authorities because the court is trying to assess what effect European law had at that date. I think I can, skip over nearly all the rest. And I just want to notice two comments in Lord Lloyd Jones's judgment, dissenting on the analysis but not on the result. Right at the end of the judgment, paragraph 2 through 2, on page 1948, in common with the majority, Lord Lloyd Jones says that the policy underlying the 2018 Act was to extricate the UK from the EU legal system and withdraw from the supervision of the CJEU. And again, that's all completely inconsistent with any alternative argument that special weight is to be given to the CJEU's judgments. And in the next paragraph, he again states the position that are in terms that are fully consistent with our case on Section 6. He says, on IP completion day, Parliament replaced the CJEU with the domestic court system with prospective effect as the ultimate interpretive authority on EU law as it still applies in the UK. That is what Lord Lloyd Jones says, and it confirms my argument. My lords, my lady, that's what I wanted to show you from Lipton. And finally, almost finally, a small comment on Skykick. My learned friend did not ask you to open Skykick, and nor do I, but he did just say to you that it concerned a similar issue and that it was surprising that it didn't mention Lipton. It's true that it did not mention Lipton, but it is not true that it concerned a similar issue. Skykick was, Lord Reed's shorter judgment in Skykick was about the status of UK trademark courts, which under the withdrawal agreement continued as European trademark courts in respect to proceedings that have been issued before the end of implementation. And because they continued to have European-wide jurisdiction, that raised different questions. Specific provisions were made for them under the withdrawal agreement, and it's just a completely different point. So that's why Skykick doesn't mention Lipton. And then, my lords, I think my last heading under this, it is indeed, was just to make some comments on the concession note that we've now seen. In my submission, the concession is both strange and unsatisfactory. It's strange because TAP Portugal, nobody was arguing it was binding, and it made no difference to the decision because it was in fact followed. So if that part of the argument is binding ratio, according to my learned friend, he should accept our case that the complete scheme approach is also binding ratio. There's nothing special about TAP Portugal. And then in paragraph 3 of the note, he draws attention to the point that my lord made to me, that he says it's common ground that the complete code analysis is strictly obiter. But my case is the one I've now given in relation to my Lord's question to me, which is that strictly obiter does not mean obiter as opposed to binding. And that is Young Sam, page 1124 of the authorities, paragraph 67, where Lord Justice Leggett specifically refers to the phrase strictly obiter. Now, because of those strange features of the concession, that it seems to be just founded on some tiny little bit to try and avoid having to argue the impossible, it's also rather unsatisfactory, because my submission is that this court should not seek to apply the Withdrawal Act without understanding what it achieves and what it means, which does mean looking at the bits of Lipton, which I have shown you as best I can. So we say that the court should do that. My learned friends in their notes say that their argument on ground 3 is an alternative argument proceeding on the assumption that ground 2 is decided against them and thus on the basis of the complete code analysis. I'm afraid, I don't understand how they say these points interact, and it may be that it just doesn't matter. But in any event, ground 2, whatever is left of it, is plainly wrong. And just to conclude, I offer 5 short points as to why it's wrong. 1, after Brexit, there is no relevant principle abrogating or varying the ordinary rules of precedent. There's none at all. 2, the claimants have not suggested that there was any relevant fact or authority that occurred or was delivered after Arcadia and before IPCD. 3, it follows from those 2 premises that the court now is bound by Arcadia as to what retained European law consisted of, as at IPCD. 4, finally, if that were wrong, an interpretive exercise is required at all, under the Withdrawal Act, the question to which that exercise is directed is how, for relevant purposes, did the principle of effectiveness have effect immediately before IPCD? And those words reflect the fundamental objectives of the legislation, which the Supreme Court in Lipton has unanimously stated to include extricating these courts from the supervision of the Court of Justice. And fifthly, having identified the correct question directed by Section 6 and the Policy of the Withdrawal Act, it is plain that post-IPC decisions of the CJEU have no special status in this jurisdiction. And in particular, the retrospective declaratory effect, about which we heard plenty yesterday, is no longer part of our legal system. So, my lords, that's what I want to say about ground 2, and that is the basis upon which ground 3 should be considered, and in relation to ground 3, I adopt the submissions that Mr. Otti is about to make.
Yes, Mr. Otti.
Thank you, my lord. My lord, we have 5 points on ground 3. First, the ratio of Arcadia clearly embraces a finding that the cessation requirement formed no part of the principle of effectiveness at the date it was decided. Secondly, there is no pre-Brexit case law to the contrary, and instead all pre-Brexit case law was entirely consistent with the exercise undertaken in Arcadia, namely of considering all individual features of a limitation regime and rejecting any notion of hard-edged requirements applicable in all circumstances, whether the cessation requirement or otherwise. Thirdly, and I obviously won't be repeating anything that's just been said, the suggested route around the doctrine of precedent for the purposes of ground 3 via sections 4, 5 and 6 of the 2018 Act is flawed for all the reasons Mr. Salzido has just given, as well as being contrary to the overall scheme of Brexit. Fourthly, Volvo and Eureka should not in any event be followed because they represented, as the tribunal below found, a dramatic and unheralded extension of the principle of effectiveness. And fifthly, the reasoning in both cases was with respect of a poor quality which should not inspire this court or any other domestic court to follow them. So, the ratio of Arcadia first, my lords. I mentioned this in my brief introduction yesterday, but if the court would turn up the judgment of Mr. Justice Simon, which is in the Supplementary Authorities bundle at tab 4. Tab 5, page 136. And the paragraph I mentioned yesterday was paragraph 11, summarising the claimant's case as pleaded, as providing the relevant background to the cessation requirement argument that we then see in the Court of Appeal. There were ongoing continuous infringements of competition law and continuing breaches of statutory duty.
Sorry, I'm not with you. Where are you looking at? What?
Oh, I'm sorry, I'm looking at
Mr. Justice Simon's.
Mr. Justice Simon.
Paragraph 11.
Paragraph 11, page 138.
Yeah.
Where there's and about 4 lines down, paragraph 77 in the amended particulars of claim asserts that the infringements of competition law concerning the UK MIF are continuous in nature, and the claimants are entitled to recover in respect of the continuing breach of statutory duty.
Yeah.
So that's the factual premise. We go from there to, very briefly again, back to the Court of Appeal in Arcadia, which is tab 40 of the Authorities Bundle, page 902. And it's paragraph 75 to 78, which are, we submit, fatal to the appellant's case on the ratio of Arcadia.
75 to 78.
75 to 78, my lord. The last 4 lines of 75.
Which page is it?
I'm sorry, my lord, 920.
920.
The last 4 lines of paragraph 75 contain the express finding that there is no basis for concluding the particular features of the Limitation Act to be incompatible with the principle of effectiveness. 76 shows, as we've already seen, that the key Court of Justice case of Manfredi was before the court via Danskiteria. 77 records the submission made in the factual context of that case that Article 10.2 of the Damages Directive and the cessation requirement it contained merely codified long-standing EU jurisprudence. And that can only be a reference to EU jurisprudence embracing general principles. And it's a submission which is then emphatically rejected by the Chancellor at paragraph 78. And then for good measure, the Court of Appeal considered the legal position to be so clear that no reference was appropriate. And obviously the Chancellor agreed with by both Lord Justice Richards and Lord Justice Patten. So whatever might be said about the preceding paragraphs, 73 and 74 in particular, in the first part of 75, and the attempt, which we say was misconceived, but the attempt to confine those to questions of knowledge and section 32 and so forth. Paragraph 77 to 78 could not be clearer. They are considering and explicitly rejecting an argument that the cessation requirement was part of EU law. So that's the first point, ratio of Arcadia. Second point, no pre-Brexit case law to the contrary. Now, in fairness to the appellants, they don't appear to contend that there was any pre-Brexit case law which was inconsistent with Arcadia. But I would like to go very briefly to each of the 3 cases referred to, Crean, Manfredi and Kogeko, for the avoidance of any doubt on this, and because they illustrate, we submit, the significance, the dramatic unheralded extension, as the CAT put it, of the post-Brexit departure affected by the claimant's reading of Volvo and Eureka. Now, as I say, the only candidates even tentatively put forward as providing a foundation for the appellants are Crean first, Manfredi and Kogeko. Crean is at Authorities tab 72, page 2240. And the first point to make is that this was not a limitation case at all. it was instead concerned with whether an absolute bar on a contracting party's ability to claim damages for breach of Article 5 could be legitimate. As such, it contains only very general statements about the importance of ensuring community rules take full effect and how, in the context of that case, the full effectiveness of Article 85 would be put at risk if there was an absolute bar on the ability to claim damages. The material paragraphs seem to be 17 and then 25 through to 31. 17 at page 2253 sets out the questions posed. 25 at 2255 contains a general statement that national courts are required to ensure that rules against unfair competition take full effect. 26 notes that the full effectiveness of Article 85 of the treaty would be put at risk if there was an absolute bar on the ability to obtain compensation. 27 makes the general point that the ability to make such claims strengthens the working of the community's competition rules. 28 rules out an absolute bar on such claims as a violation of those rights. But 29 then emphasises that in the absence of community rules, it was for each domestic legal system to lay down rules provided only that they complied with the principle of equivalence and that they didn't render the exercise of rights practically impossible or excessively difficult, the core wording of the principle of effectiveness. So again, emphasising that absent community rules, this was primarily a matter for the domestic legal system, with those two general safeguards, but not hard-edged requirements. 31 accepts that some domestic rules which have the effect of preventing a claim for damages in a competition context are still consistent with EU law. The example given there is a rule that prevents a party who themselves bears a significant responsibility for distortion of competition from bringing such a claim. So Korean doesn't advance the appellant's case at all and doesn't provide any sort of platform for what we then ultimately see in Volvo and Eureka. It's a very long way from providing a basis for treating a cessation requirement, or indeed anything else, as a hard-edged component of the principle of effectiveness. And the tribunal was right, therefore, at 32.1 of its judgment below, to say it said nothing about the cessation requirement. Now, Manfredi is next, and that is a couple of tabs further on.
No, it's the same. It's the next tab, 73. Right?
Oh, so I'm so sorry, Molly. Yes, it is the next tab, 73, page 2258. We've addressed it in our skeleton argument at paragraph 49 for the court's note. The case concerned an anti-competitive agreement between vehicle insurance companies which had caused policyholders to pay excessive premiums. That's paragraph 2. And the point I made yesterday, again in introducing our response to the appeal, one of the specific issues raised with the court was whether Article 81, predecessor of Article 101, meant that for limitation purposes, time ran from the day a practice was adopted or the day it was brought to an end.
Where's that?
That's paragraph 23, first of all, at 2276. Just by letter C.
Letter C. Paragraph 23.
So I'm sorry, no, paragraph 20, subparagraph 3, on page 2276, by letter C. Mm-hmm. You'll see, this is one of the questions, is Article 81 to be interpreted as meaning that for the purposes of the limitation period for bringing in action for damages based thereon, time begins to run from the day on which the agreement or concerted practice was adopted, or the day on which the agreement or concerted practice came to an end. So squarely cessation requirement territory. Same point in the fourth subparagraph to paragraph 21.
Sorry, I'm afraid I can't see those words.
I'm so sorry, my lord. Do you have page 2276?
Yeah, I'm on page... Oh, 2276.
Yes,
You
ma'am.
said paragraph 21. Oh, I see. I'm in the Advocate General. Sorry, that's why I'm being confused.
Yes, I'm sorry, my lord. Paragraph 20 of the judgment page 2276.
Yeah.
And your Lordship should see
It's
by
sub 3 you wanted, wasn't it?
Yeah.
subparagraph 3 by letter C and subparagraph 4 of the next paragraph just after letter H.
Yeah.
So, by both questions, the cessation requirement as now contended for was one of the specific scenarios the court was invited to consider. The questions raising that issue were then addressed at paragraphs 73 to 79, beginning at page 2284, with the heading, the third question and the fourth question. And the court's analysis begins at paragraph 77. And the court explained at 77 that there were no community rules applicable beyond the principles of equivalence and effectiveness, and that subject to those principles it was for each member state to lay down relevant procedural rules. 78, it said simply that a national rule which provided that time began to run from the date of adoption of a practice could, and I of course emphasise could, not would, make it practically impossible to exercise the right to seek compensation, particularly if accompanied by a short limitation period incapable of suspension. 79, it said in such a situation, in a case of continuous or repeated infringements, it was possible that a limitation period could expire so as to render it impossible to bring a claim. Now, just pausing there, as well as talking in terms only of possibilities, it's notable that in this paragraph, the court is apparently contemplating a different national limitation rule than applicable under English law, because it's contemplating the commencement and expiry of a single limitation period, rather than the accrual of individual and fresh causes of action, and the commencement of fresh limitation periods with every instance of a continuing infringement. And then at 80, and this is the passage I asked Mr. Moser to read out yesterday when he was on Manfredi, the court then said that it was for the national court to determine whether it was the case that a limitation period made it impossible.
That was always the received wisdom as far as the principles of equivalence and effectiveness was concerned, is that the principle was clear as a matter of European law, but it was for the national court to decide if the principle had been applied.
Exactly, my lord, having regard to all the different features of its own.
Is that a point that goes to the nature of the overreach that you say Volvo and Eureka effect? Because in the old days, the CJU always held back from saying this is a breach of the principle of effectiveness. It would say this is for the national court to decide. The principle is this, and you apply it. Now they've said the principle of effectiveness actually requires every limitation, if they're right, every limitation provision to comply with the cessation requirement, which is quite a different kind of thing. But we're seeing here, they're not saying that at all.
Exactly so.
They're saying it might.
I'm sorry, my lord.
They're saying it might.
Yes, my lord, but they're saying over to the domestic court to decide whether it does.
Yeah.
Well, indeed, in my reading, the specific scenario they're considering is where the limitation period runs from the date the concerted practice was adopted. So, starting with that's what 78 says, and 79 says in that situation. In other words, I know this. It's important because this sentence in 79 is picked up later. In my reading, it applies to quite a different scenario.
My lord, my lady, it does. I think I make 2 points on this, really. One, as we saw from the questions referred, the court was presented with an opportunity to say, if it were the case, that the cessation requirement was part of the principle of effectiveness. And it hasn't accepted that invitation.
No, it simply said it's a matter for the national court to determine whether a limitation period that expires, that commences on the date when the relevant agreement was adopted, and then has a short limitation period, does or does not comply with the principle of effectiveness. And what you say is, well, that test is precisely the test that was applied by the Court of Appeal in paragraph 75 of the Arcadia judgment.
Exactly.
Mr. Tarrant says in terms, I see no good reason why the barring of claims in respect of any period prior to the limitation dates in the present proceeding should be held to be infringement of the EU principle of effect.
Exactly so, my lord. So that exercise and test was exactly what was undertaken and applied in Arcadia. And to my lord's point, yes, we say this does very much illustrate the dramatic shift which, on the appellant's interpretation, Volvo and Eureka represent. And Mr. Moser, in fairness, got quite close to conceding this yesterday by saying, when I asked him to read paragraph 80, oh, well, that was 20 years ago, and the Court of Justice used to be much more respectful of national courts, and then they perhaps got a bit impatient, viz. Eureka. Well, whether that's the explanation for why the Court of Justice expressed itself in the way it did in Eureka, the one thing it does do is illustrate the dramatic shift, and illustrate that.
And we've got a bit more forthright as well.
I toned down my summary of
Everybody's
criticisms of reasoning with the court.
Banging on the table.
Your lordships have got more forthright in the post-Brexit cases we've seen, and that's as it should be in the post-Brexit world. We respectfully submit. In any event, the point is, Manfredi is entirely supportive and consistent with the Court of Appeal's approach in Arcadia and our submissions on this appeal,
Right.
rather than providing a platform for Eureka and Volvo. That was also, for what it's worth, the approach of the Advocate General in his opinion in that case. And just
Manfredi.
I'm sorry, my lord, in Manfredi, yes.
Yeah.
And that's page 2271, paragraphs 59 to 60, the Advocate General pointing out that there were no community rules governing limitation commencement dates. 61, stating that in those circumstances it was for the domestic legal system to lay down the procedural rules, provided only that the principles of effectiveness and equivalence were respected. And the Advocate General, like the court after him, declining to answer the specific question about whether a limitation period should start on the date of adoption of an unlawful agreement or practice or the date it came to an end. So neither the Advocate General or the court accepting the invitation to provide a hard-edged answer, as I've submitted. Now, this was the point emphasised by this point about the court having resisted the invitation made to it, was the point emphasised by the tribunal in its judgment below at paragraph 28.1, when addressing Manfredi. So while the appellants are right, we respectfully submit, to characterise the Manfredi decision as part of the established and consistent case law of the Court of Justice, they fail adequately to confront the fact that their approach in urging a hard-edged cessation requirement is directly counter to it. Kageko is the only other pre-IPCD case cited by the appellants, and it took a similar approach of emphasising Kageko.
Sounds like a lizard.
It does, there are many interesting
strange
names which I
pronunciation.
fear the transcribers will battle with before a perfected version reaches us later today. This is COGECO, and the court has it.
Kojiko, possibly.
No K in it.
Shall I go for Kageko, my lord? I'm sorry.
I don't mind. It's just when you say Kogeko, I don't know what you're talking about. That's all. Yeah.
Tab 76, page 2360 of the bundle, took a similar approach of emphasising that while the general principle of effectiveness of course applied, it was always necessary to look at all aspects of a domestic regime relating to limitation in combination before deciding whether it was infringed. So back to the exercise in Arcadia.
So this is relatively recently, actually.
This is relatively recent.
This is March
and it's,
2019.
But it's 2019, but it's pre-Brexit.
Yeah.
Pre-RTC.
It does post-date Arcadia.
I'm sorry.
It post-dates Arcadia.
It post-dates Arcadia, my lady, yes. So the judgment, paragraph 1 of the judgment at 2378 we've got the Advocate General's opinion first, as before. The Court of Justice summarised the case as concerning the interpretation of the Damages Directive on rules governing actions for damages under national law, as well as Article 102 and the principles of equivalence and effectiveness. It sets out the key provisions of the directive at paragraphs 2 to 8, including among them Article 10 at paragraph 6 and Article 22 at paragraph 8, the cessation requirement provision and the non-retrospectivity provision. It then sets out the Portuguese limitation period in issue in the case at paragraph 9, with its provision for a 3-year limitation period to start from awareness of a right to compensation, even without knowledge of the identity of the person liable or the full extent of damage suffered. So, by way of contrast, of course, half the primary limitation period applicable under the Limitation Act, and no equivalent of Section 32, and no indication that under Portuguese law a fresh cause of action accrues with every instance of a continuing infringement. Paragraphs 20 and 21 on page 2381 set out the rival contenders for commencement of a limitation.
2382, I think.
Oh, I'm so sorry. Well, yes, I don't know what's gone wrong. No, 2382, I'm sorry. The rival
20 and 21.
20 and 21, the rival contenders for commencement of a limitation period are set out, including among them, in the fourth line from the end of 20, the date on which the anti-competitive practice had ceased.
Yeah, date on which it ended.
Yes. The questions in the reference are then set out at paragraph 23, and it's the second question at 23.2 is relevant here, with its reference both to the directive and to general principles of EU law. And the court then held at paragraphs 24 through to 34 that because the claim had been brought before the deadline for transposition of the directive had expired, and because Portuguese law gave the transposing provisions prospective effective only, the directive was not applicable ratione temporis. It then began consideration of the second question from 23 at paragraph 35. Paragraph 42, it stated that in the absence of EU rules, again, it was for the domestic legal system of each member state to lay down detailed rules, including those on limitation.
So which paragraph?
42, my lord, on 2386. At 43, it set out what those principles were within terms of the principle of effectiveness, the formulation we've already seen. 45, it emphasised, as the Advocate General had done before it, as Arcadia did the Court of Appeal did in Arcadia, that it was necessary to undertake a detailed fact-sensitive inquiry, taking into consideration all elements of the Portuguese rules. At 46, it referred to the complex factual and legal analysis which EU competition law required. 47, it emphasised the limits on national legislation in relation to when limitation periods started to run, their duration, rules for suspension or interruption, and stated that they could not undermine completely the full effectiveness of Article 102. And 48, the court stated that it followed that the combined effect, the word combined is in 48, combined effect of all limitation rules could not be such as to render exercise of the right to claim practically impossible or excessively difficult. So again, emphasising the need to look at the totality of the picture and eschewing the idea of a hard-edged rule, despite the fact that in this case, for the first time, the court actually has the damages directive before it, and actually has Article 10 before it. So could have said, well, actually Article 10 already does no more than codify pre-existing law. So nothing to support here the idea that Article 10 did simply affect that codification. Nothing to justify treating a cessation requirement as a hard-edged aspect of the principle of effectiveness. Nothing to displace the idea that anything other than a fact-sensitive inquiry by the national courts is required. Now, in taking that approach, the court reached the same, took the same approach as the Advocate General, but there is a small number of additional passages in her opinion which I'd wish to emphasise. They're at paragraphs 72 to 83 on page 2374 and 2375. Paragraph 72 set out the question, and paragraph 73 referred to the conclusion that the case fell outside the temporal scope of the directive, such that the limitation provisions in issue failed to be measured only by the yardstick of the general principles of EU law and not by the standard of the directive. 75 emphasised that absent the harmonisation brought about by the directive, it was for domestic legal systems to prescribe rules subject only to the principles of effectiveness and equivalence. 77 explained that a detailed examination of any relevant rule was required to assess whether it was the principle of effectiveness. And paragraphs 78 to 79 set out the conclusion that even a 3-year period of limitation was not per se too short to comply with the principle of effectiveness, even though less generous than the 5 years set out in Article 10.3 of the directive. And paragraph 80 contains the clearly stated view, not contradicted by the court and consistent with its conclusions as we've seen, that Article 10.3 of the directive was not to be understood merely as a codification of that which had already resulted implicitly from primary law in the form of Article 102 and the principle of effectiveness. So that rejection of the idea of codification is again entirely consistent with the approach taken in Arcadia. And it's against that background that it's no surprise at all that, as the tribunal noted at footnote 66 of its judgment, core bundle page 200, prior to Volvo being decided, no claimants had contended that any case law had established hard-edged limitation rules equivalent to Article 10 and flowing from the principle of effectiveness. Now, as I say,
Well, I suppose the closest you get to it is paragraph 53 of the judgment, isn't it? 2387, which you didn't take us to. In that context, it must be held that a limitation period of 3 years, such as that at issue in the main proceedings, which first starts to run from the date on which the injured party was aware of its right to compensation, even if the infringer is not known, and secondly, may not be suspended or interrupted in the course of proceedings before the National Competition Authority, renders the exercise of the right to full compensation practically impossible and excessively difficult. So that is saying that a limitation period that doesn't have those characteristics, yes, would breach the principle of effectiveness.
yes, my lord.
But of course, it's focusing on
those characteristics.
on those characteristics, and also focusing on whether or not the absence of suspension or interruption does infringe the principle of effectiveness.
Yes, it's performing exactly the exercise that it said is appropriate at 48 of looking at all the features of the particular limitation regime in issue. The only development that you perhaps get from Kogeko in this respect is that the court is showing the confidence to undertake that exercise for itself.
Yes.
But it is firmly supporting the idea that you've got to look at all the individual features of the regime.
Could be said that it's giving guidance as to how the principle of effectiveness is to be seen in the context of limitation.
Yes.
Because it's not actually, first of all, it doesn't deal at all with the cessation requirement in that paragraph.
No.
And secondly, it is just, I mean, I don't think it is actually applying the law to the facts, but it's perhaps coming close to doing
Yes.
that, which could be an objection. But anyway, it doesn't matter. It's not, and it cannot be said to be the same as Volvo and Eureka.
No, it's not. It's not laying down a hard edge requirement applicable in all. It's, as I say, performing the exercise that had been described in 48.
Yeah. Okay.
And as I say, the other thing one gets perhaps from this judgment is that it's the first case, the only pre-Brexit case, where the court has both the damages directive in front of it and principle of effectiveness in front of it.
Yeah. And it says it's not codified.
It says it's not codified.
Not again.
Or it's not saying it is codified. So that's our second point. As I say, in fairness to my own friends, not seriously disputed, but it's an important platform for what I've come to later and what my Lord the Master of the Rolls has already observed. It illustrates the dramatic shift that Volvo and Eureka affect.
Yeah.
Third point was no route around Arcadia via sections 4, 5 and 6 of the 2018 Act. And as I say, I'm not going to repeat anything that's been said, and I gratefully adopt what Mr. Salzido has set out. I'd just like to give the court one additional reference and document, which is again one I foreshadowed in what I said yesterday. It's from the Secretary of State for Brexit's presentation of this legislation to Parliament, and it's at tab 87, page 2573, in the second column.
This is Hansard, is it?
This is Hansard, yes.
Okay.
And you see there Mr. Davis making exactly the point that we both made about the effect of this section 6, 1 and 2 rendering Court of Justice judgments similar to Australian or Canadian judgments.
Oh, yes.
There's no hint anywhere in any ministerial statements that we've seen or any explanatory notes that we've seen that there was ever any intent to vary the domestic law of precedent.
Yep.
I'm in the court's hands. But before leaving this third point, I was going to just very briefly address the Elkinov argument that is in the Learned Friend's supplementary skeleton argument at paragraph 31, which is Elkinov was the case confirming that where there was an intervening Court of Justice decision, a lower court was entitled to depart from a higher court's judgment. And again, this is something I touched upon briefly yesterday, but unsurprisingly, that was nothing more than a conventional application of the doctrine of precedent as it existed in the pre-Brexit world, when the Court of Justice sat supreme.
Yeah.
And that is evident, if one goes to it very briefly. Tab 75, page 2312, you have Elkinov. And the material paragraphs, which are the ones cited by my learned friends, are at page 2348, they're paragraphs 29 to 30. And as I've just submitted, the premise or the principle articulated in these paragraphs is that a Court of Justice judgment is binding on a national court, so as not merely to permit but to require earlier inconsistent higher court rulings to be disregarded in the light of a subsequent Superior Court of Justice ruling. As I say, an entirely conventional application of the doctrine of precedent, but not the position here, because the core premise for it is absent as a result of the 2018 Act. The binding status of the Court of Justice having been removed, as the words of section 6.1 make abundantly clear. I mean, at one level, this case could and should perhaps have been extraordinarily short, both below and in this court, by reference to Section 6.1, Arcadia and now Lipton. There's really no answer to the inevitable consequence that each of those lead to. So that's our third point. The suggested route around Arcadia is not available. The fourth point, the dramatic and unheralded extension of the principle of effectiveness. Well, I hope that the review of Korean, Manfredi and Kogiko make clear that there's nothing in the pre-Brexit case law to foreshadow, let alone found what comes in Volvo and Eureka. As we've seen from the arguments advanced and the factual premises in place, and in one case the questions actually posed to the Court of Justice had at least two opportunities to treat the cessation requirement as part of the principle of effectiveness, or to treat Article 10 of the Damages Directive as codifying pre-existing law, and it failed to take those opportunities on either occasion. Now, the Tribunal's conclusions on this were set out at 28.1 to 3 of the judgment below, and they were, with respect, entirely justified. At 28.1, Core Bundle 198, the Tribunal rejected the argument that the cessation requirement somehow represented a logical development of the law on the principle of effectiveness, contrasting, as I've submitted, the approach taken in Manfredi. And the Tribunal again rightly held, instead, the cessation requirement would be a dramatic extension of the principle.
So it's impossible to navigate this judgment because there's
There are a lot of subparagraphs, my lord, yes, I'm sorry. So page 198 of the core bundle.
Do you have any idea where it is in the internal page numbers?
28.
28.
Page 28.
Very grateful to my lord.
It is.
So yes, internal page core bundle page 198.
Thank you.
So that's 28.1, 28.2.
So hang on a second. I'm
Yes,
sorry. Is this part of his reasoning or their reasoning that says that Volvo didn't actually express the hard-edged principle?
No, my lord, it's part of. Well, it's under that heading.
Because he said, I mean, I wondered how far you
But it
sought to. Just let me finish. I wondered how much you sought to uphold the tribunal's suggestion that it was only the dispositive and not the rest of the reasoning, and therefore it didn't actually say what Eureka makes perfectly clear it did say. Do you seek to go anywhere with that?
Yes, my lord, that's what Mr. Salzido will address under ground one. I'm presenting my arguments on the assumption that the appellants are right as to what Volvo and...
Does it matter? I mean, do you say Eureka doesn't have a hard-edged? If it's unheralded and dramatic, surely it must change something.
Yeah.
Yes, my lord. It's on
Yes,
it, but
yes,
there
my
are
lord,
two
what?
questions. My lord.
Yeah.
One, does it change something? Two, what part of it is binding? Does it change?
Yeah, I mean, your point here is that what they said in Volvo in the reasons
Yes.
was unheralded and was a new development.
Yes.
Separate question whether what they said in the reasons was binding because of the point about dispositivity.
Exactly, and that's the ground
And
one.
that's a different issue.
But
For
the
present
ground-
purposes, you're on the first of those questions. Is that right?
That's right, my
Yeah.
lord. I'm very grateful.
And this was a submission, in fact, by counsel for Merrick's, I think.
Yes.
Yeah.
Who didn't ever argue the non-binding point, but said, oh, it's all of a piece with what came before, so just follow it on that basis.
Yeah.
And that's being rejected. And so 28.1, we get...
We think it would be a dramatic extension.
dramatic extension of the principle unheralded in any of the prior authorities. Agreed, we say. Respect. 28.2. 2, and this is a point I'll come to as my my 5th point, poor quality of reasoning. The bald statement that the principle of effectiveness incorporates a cessation requirement for the start of the limitation period is not supported by any reasoning.
Yeah.
28.3, drawing attention to the position as it was at the time the CAT gave judgment, that the Commission was itself arguing at that point in Eureka that Volvo should not be followed. And then this is all referred to again, but with a summary as to the consequence as the CAT saw it for the English law of limitation at paragraph 73 on page 241 in the core bundle, page 71 of the internal pagination of the judgment, where the tribunal concludes in the final 4 lines, even if the Volvo decision had held what the claimants contended for, introducing a cessation requirement into the limitation scheme that operates in England would do such violence to a well worked out scheme that we regard this as inappropriate and unnecessary. All of those observations we respectfully submit, save for the baldness of the reasoning point, which I'll come to next, all of those observations are, with respect, entirely justified when one lays side by side Korean, Manfredian, Kogiko on the one hand, and the passages relied upon from Volvo and Eureka on the other. And that takes me then to the poor quality of reasoning in Volvo and Eureka, which even if, we of course say the court doesn't get anywhere near this stage of the debate, even if the court were able to consider following Volvo and Eureka, that would not be an attractive course to follow because of the deficiencies.
So you say we can't follow it?
Exactly, Michael. We don't get there because of Arcadia, and so it may be that the court's judgment doesn't need to be as forthright as it's shown.
Lest we be tempted.
Lest you be tempted to observe on the quality of the reasoning, my lord. We say it doesn't pass much muster.
No,
Shouldn't invite devotion, let alone following.
We try generally not gratuitously to criticise other courts, and I would have thought that our view about the Court of Justice is very much that. We don't have to here. Why should we?
It would be a red rag to a European bull, really.
My lord, I'm, as I say, entirely in the court's hands. If we don't need to get there, then I won't go through the points. But
I mean, I also think it's a difficult point when there has been legislation which actually brings it into effect, including in our own jurisdiction. So it seems to me just a rather bridge too far, Mr. Arty.
Well, my lord, I'm not saying that you can't make a policy case for the damages directive, of course, or for the legislation.
I understand the distinction between
Yes.
making a policy case and saying that the reasoning for saying it was part of existing EU law is different. But in a sense, it's not for us, particularly now, after we've decided not to use the CJEU as our apex court, to say that the change of policy from simply asking the national court to apply the principle of effectiveness to letting the CJEU apparently apply the principle of effectiveness, which might be said to cut across some other aspects of the regime under Article 27, the reference regime, 276, whatever it is, might be said to. But I mean, it's not for us to comment on that unless we need to.
I agree, my lord, and if we are right collectively on Arcadia, at least at that level, you don't need to.
No, Arcadia's, you say, binding, end of story. I mean, You know, this is really quite a simple case. I think I said that yesterday.
You were, with respect, entirely right to say that yesterday, my lord, and we certainly see it as that.
Well, you said a moment ago it could have been dealt with very shortly.
And I'm not prejudging Mr. Moses' reply, which I'm sure will bring us completely back to his point of view.
My lord, as I say, I'm in your hands. We say the tribunal's finding that the reasoning in Volvo was bald was entirely justified.
Yeah.
We say that that is not materially improved by Heureka, although Heureka is longer.
Okay.
I should, as I say, my lord, I'm in your hands to the extent to which you would like me to go through these.
And if you're in our hands, you don't need to go
No,
through.
I don't think we need to.
I'm grateful, my lord. Perhaps one point I could just.
So you're not in our hands after all.
Well, not for quality of reasoning, but accuracy of understanding as to what Heureka did actually decide, without the need for any pejorative remarks about it. You were taken to two passages in the Advocate General's opinion, where reference was made to Manfredi.
Have you got a paragraph number or page?
Yes, my lord. I think it's. Forgive me, I'll just find it. I think it's 83. Let me find. Sorry.
98.
Sorry, 98.
98.
Page 2504.
2504.
Yeah.
Yes, where the Advocate General says similarly at 78 and 79 of Manfredi, the court held and so forth, having in the previous paragraph referred to Volvo. That passage in the Advocate General's judgment referring to Manfredi is not one referred to, cited by the Court of Justice in its judgment. And so this, in some respects, is an element in which I commend the Court of Justice for not going down a wrong path and concluding that Manfredi had already laid the foundations for Volvo and reached a similar conclusion to Volvo. And as we've seen from Manfredi itself, it manifestly didn't. And then just over the page, in the Advocate General's opinion, you, my lord, asked yesterday whether either of these cases had considered what your lordship summarised as the Chancellor's point in Arcadia, namely, if this was already there, what was the need to legislate for it in the damages directive? And you were told that that hadn't been addressed in so many words, but that it had featured in the Advocate General's. That again is that was a reference, as we understand it, to paragraphs 103 and 104 of the Advocate General's opinion on page 2505, where you see the submission about the directive establishing an entirely new legal reality and so forth. And then the sole response to that is paragraph 104. That line of argument cannot, however, be accepted, but it's never developed as a basis for rejection. It's not quite the piece as articulated there as my Lord's summary of the Chancellor's point, and it doesn't feature anywhere in the judgment. If this goes to the Supreme Court, I obviously would or may need at that point to make all the points I have about poor quality of reasoning. So, of course, I don't want to be treated as having conceded anything, and we maintain, as I say, the core submission that the tribunal was right on bald reasoning, and the Court of Justice in Heureka, while producing a longer judgment, didn't materially improve the quality of that reasoning.
Right, good.
My lords, my lady, unless I can attempt to assist further, that is all I wanted to say on those 5 points on ground 3.
Thank you.
Well, Lord, ground 1. Yesterday, Mr. Moser criticised the CAT for misunderstanding what counts as binding ratio in an EU decision. I mean, it may not be that critical what counts as binding ratio, since no one's saying today that they're binding at all. But it's a little unfair to criticise the CAT. If your lordships and my ladies see the skeleton argument of the appellants at Core Bundle, tab A, page 94, all they said about this in their skeleton was that it was common ground, as recognised in the CAT judgment.
So, which paragraph?
I'm looking at page 94 of the bundle, footnote 7 of their skeleton.
Footnote 7.
Yeah. Where they say it was common ground, as recognised at CAT 24 to 25, that the binding effect of CJEU judgments attaches to its operative part and the reasoning that underpins it. So it's a little bit unfair to criticise the CAT for failing to understand.
Well, the reasoning that underpins it is a sort of slightly general exposition.
Yes. Well, it is, and so, but the relevant point is that the starting point for understanding what is intended to lay down binding principles in a Court of Justice decision is the operative part.
I mean, do we need this?
Well, quite possibly not.
What is it? Where does it take us? I mean, everybody acknowledges in their skeleton arguments that it's Eureka now that is relevant. What the tribunal thought of Volvo, and
It's actually academic.
It's completely academic.
Well, what they thought of Volvo is certainly academic. The issue on Eureka is that my submission is that Eureka itself simply says that the check rules fall outside the principle of effectiveness. Now, as you've heard, on ground 3, which may be the more important one, we have made submissions on the footing that that's wrong, and that Eureka does represent the change which the claimants contend for and push the bill back. We do submit that it does not say that. But whether that matters is I accept a rather unclear. But if my learned friend Mr. Moser is right that this court ought to pay some kind of serious weighty regard to Eureka, then
He says we have to follow it.
well, he says you have to follow it. So in that case, I think I should just make submissions, if I may, that Eureka does not, in fact, lay down a rule of cessation requirement.
Yes, I wasn't discouraging you from making submissions that Eureka, if that's what you want to say, did not lay down any rule we could follow, but
It's the
I
point
want
about the
Volvo.
dispositive of Volvo that seems to me to be a fairly arid
Well, I agree. So
debate in the light of Eureka.
yes, well, I'm quite happy with that. So let's. I entirely agree. So if we go to Eureka,
Eureka.
which in the
80, isn't it? That 81?
oh, yes, 81. So sorry.
Tab 81.
81. In my submission, the starting point is the dispositive at page 2529 of our bundle. And where the court says, just after paragraph 95, on these grounds, the court hereby rules that Article 10, on certain rules, etc., and Article 102 and the principle of effectiveness must be interpreted as precluding national legislation, as interpreted by the relevant courts, which lays down a 3-year limitation period applicable to actions for damages in respect of continuing infringements, and which starts to run independently and separately, may not be, and then
It may not be suspended.
yeah, and may not be suspended. And furthermore, Article 10 precludes them. So, first of all, just looking at the operative part, what rule are they laying down? They are laying down the rule that the check limitation rules, including in particular a 3-year limitation period, doesn't meet the principle of effectiveness. That's what they say. Now, and at one point, my learned friend Mr. Moser, I think, sort of said, well, this case is all about the word and, as if to suggest that somehow wasn't a real point. But it is a real point. That which does not comply is a regime of limitation which contains all of those features. That is what is clearly stated. And if we go back through the reasoning, I'm not going to go through very many paragraphs, we see that that's not an accident. If we go back to page 2520, paragraph 42, we can see the court's traditional reformulation of the question. And in their formulation of the question they're going to address, it contains all the same ands. It's the same point. They're going to address the question whether the rules of check law comply. And the entire discussion is in fact framed that way. Of course, I accept that they give policy justifications for some of the rules as well, as to why it might be a good idea to have a cessation condition. I accept they give those things, but it's all framed in terms of answering that question. We see it at paragraph 62, where they refer to the rules which provide for a limitation period of 3 years, etc., etc. And we see it again, perhaps importantly, at paragraphs 81 and 89, framing a key passage of reasoning. So framing that reasoning at paragraph 81, and then again at 89, they are asking themselves the question and addressing the question whether the check rules taken all together comply. And that's 81 and 89.
What about 63?
Well, that, as I say, as I've accepted, there are statements here, including paragraph 63, that there are policy advantages to, for example, the cessation condition. There's no doubt that they say that. I accept that. They do say that. But what they do not do is they do not say that the cessation condition is an essential requirement of meeting the principle of effectiveness.
For all cases.
Yeah, but that's what they don't say. They say that the cessation condition is one thing that would have a beneficial policy effect, and they refer to other things as well. And they say then when you look at the check rules, it doesn't overall.
Of course, they don't frame it in terms of the check rules specifically, and that's because they're supposed to be giving guidance to national courts generally. They're not just answering a question of how European principles should be applied in the Czech Republic, are they?
Well, in my respectful submission, that's not the right way of looking at it. In my submission, the right way of looking at it is to say, well, what's the question they're asking, and what answer do they give, and what's the essential reasoning to that answer? And the essential reasoning nowhere says that you cannot comply with the principle of effectiveness unless you have a cessation condition. It's just not in here.
Well, that's why I put 63 to you.
Yes.
Because if you strip away the sort of the customary language of the court, it actually says, as the Advocate General noted in essence, and you strip all that away, that cessation of the infringement as a condition which must be satisfied in order for the limitation to begin to run may have a deterrent effect and lead the perpetrator of that infringement to bring that infringement to an end sooner, which I must say reads to me as if it's saying that's what we're saying it is required. Now, I mean, and I agree that's not, you know, to an English lawyer, we would much prefer it to say it is an essential component of the European law principle of effectiveness that the cessation requirement is observed within the legislation, but that's not, it's quite close. It certainly seems to be looking at it as an obligatory thing to be satisfied.
My lord, I'm afraid I can't do much other than say that I simply disagree with that, and I will be repeating myself. But that is saying there is a benefit in policy terms to having this condition. It is not saying there is no other way to comply with the principle of effectiveness.
Well, then it goes to the dispositive, and it says that that is one of the criticisms of the Czech legislation.
Well, with respect, it doesn't say that. It says that a limitation regime with the following characteristics, one of which is the missing cessation condition, with all of those characteristics, including in particular a 3-year term, which they mention over and over again.
Well, they do, but look, for example, at paragraph 60 as well. I mean, what difference does a 3-year term make to that point?
Well, the point in paragraph...
Well, 60 is about the partial harm, and it's if you're forced to rely on a system under which compensation gradually increases, that renders the exercise of the right to full compensation practically impossible or excessively difficult. I mean, the point really is that the material difference from the Czech system that you're relying on seems to be the 3-year requirement.
Well, that's one of the differences. There's also a difference, I think, in terms of what the knowledge that's required, which was rather less in the Czech system than it would be in the English system. But it seems to, but my submission is that the entirety of this section is, if we look at 59, it begins with "in these circumstances."
Well, yes, because it's starting with 56. As regards the first condition relating to the cessation of the infringement, it should be noted in the first place that it's apparent from the settled case law that the bringing of actions are complex, complex economic analysis. Disputes concerning infringements of the rules on competition law are characterized by information asymmetry. Moreover, it's particularly difficult for the injured party to establish the existence of the infringement. In those circumstances, the requirement that the limitation period can't begin to run before the infringement concerned has come to an end is necessary in order to enable the injured party to identify and prove its existence, etc. I don't see how you can say that's not what it's saying.
Well, my submission is then the conclusion of that section is paragraph 62, which I referred to before. And so my submission is that if this is simply in the context of saying, of the question that they are asking themselves, which is whether a system with all of those features does or does not comply, and they conclude that it does not. But it may not. I mean, well, so that's my submission, is that is the right way to look at the judgment, to ask what is essential to the Czech system not complying. But it's very much an illustration of the difficulty when one can't refer, because if this came up whether the UK is different, I mean, let's say you had a system where instead of 6 years, 3 years in Czech, 6 years in England and Wales, let's say you had 20 years. Would that make a difference to the reasoning? Well, we'll never know whether the different features of the English system make a difference to the reasoning, because we can never refer anything.
This is the problem with the Court of Justice. Really taking a different line from what it used to do. Because it used to say what the principles were and leave the national court to apply them, sometimes with great difficulty, in my experience. But now it seems to be actually applying them, but in a way that makes it difficult to discern the principles. But 559, to me anyway, using the word necessary is something that I would, find it hard to say it wasn't trying to express that view.
It seems to me the 56 to 60 taken together is really the court saying a limitation regime that does not include the cessation of infringement condition does not comply with the principle of effectiveness.
Well, I think my response to
I mean,
this
it
question
seems to me, I'm not entirely sure, Mr. Salcedo, why you're pressing this point, because it seems to me that that formulation I've just given you, if it is correct, on any view, goes way beyond anything that any of the cases prior to Volvo had said, and therefore entirely supports what the CAT said, which was that this is an unheralded development by the European Court. You could describe it as overreach, whatever, but it goes way beyond anything in Manfredi or in Cogico, or whatever we call it. And that's a much better point from your perspective, your combined perspectives.
My Lord, I entirely agree. That is our primary case. We've put things in the order we've put them. And so I'm entirely happy if the court finds in my favour on that basis.
I mean, the problem with it, to my way of thinking, it's a little more nuanced than saying it's unheralded and outrageous, or whatever language you use. The greater nuance is that this is a departure of approach by the European Court, which is, instead of laying down the principles and the law that is applicable to the facts of a particular case, of a particular regime, it seems to be getting into the weeds of applying them. And that is a hindrance to national courts who really want to have a set of principles they can apply, rather than knowing how certain unstated or unclearly stated principles apply to another regime. Because it is absolutely clear that the Court of Justice is intended to lay down principles applicable to every one of the member states, right? Not just Czech, just because this is a Czech case. And so the problem I find with this judgment is not that it's unheralded or a great departure, because we've all legislated in the same way, so it's hardly a big departure. Just, you can be completely overstating that point, frankly, when Article 10 says exactly this. What is the problem is it's taking a different approach to its own role.
Yes.
And it may be that just means for us we say nothing about it, and we say, well, there we are, we know what you've said, it doesn't apply to us anymore, and off you go.
And of course that way of looking at it emphasises the point I was making earlier of what we have domesticated is the principles and some of the specific laws, but what we have pulled away from is the supervision of the court.
Exactly, and you don't need any more than that. I mean, if you're right on your first points this morning, I mean, that's the critical point in the case, it seems to me. And if you were wrong about that, then you may well lose the case, plainly. But you're not going to win the case by showing us that Eureka didn't say what it was obviously saying. If I may say so.
Your Lordship may say whatever you wish to say. Your Lordship's called.
You win. There are good points and not so good points, and the first point is the one that matters.
Yeah.
Where we started yesterday.
My Lord, there's a very small, even smaller further point on ground 4, which Mr. Johnson is going to argue on that side. I don't know if your Lordship is willing to hear that.
We're very willing to hear Mr.
He wishes
Johnson, even if we didn't think the point was particularly relevant. Mr. Johnson.
My lords, my lady, I'm in your hands as to whether I address you now or after the short adjournment.
Oh my goodness, it'll be after the short adjournment. I got so engrossed with the argument that I hadn't noticed, which is very unlikely.
stimulating.
2 o'clock, Mr. Johnson. How long do you expect to be?
I don't anticipate detaining you for more than
Lovely. We look forward.